We acknowledge the traditional owners of the land on which this podcast is recorded, the Wadawurrung people, and pay our respects to their elders past, present and emerging.
G'day, it's Chris McKenzie here at WorkSafe with another episode in the HSR podcast helping you achieve better health and safety outcomes in your workplace. This is a series offering advice, guidance and support on a range of topics for health and safety representatives, employers and employees from industry experts and leaders in OH&S. It's all brought to you by WorkSafe, Victoria's occupational health and safety regulator and workers' compensation insurer. We are here to reduce workplace harm and improve outcomes for injured workers, offering education, support and guidance for Victorian workplaces to provide that safe environment, but also to hold employers to accounts if they fail to protect their workers. But the role of health and safety representatives, or HSRs for short, is so important because WorkSafe can't be at every workplace all the time. HSRs provide that crucial link between employers and employees in workplaces across Victoria. In the last few episodes of this series, we've heard about how health and safety representatives are elected, what powers they have and what obligations employers have towards them, and some tips on resolving OH&S issues in your workplace. Make sure to catch up if you've missed any of the first 7 episodes. In this podcast, we're going to discuss discrimination under the Occupational Health and Safety Act with Colleen O'Grady, who's an investigator with WorkSafe's Enforcement Group, and Chris Walker, WorkSafe's Regional Director of Operations. Colleen, could you start by telling us a little bit about yourself and your role at WorkSafe?
Yeah, my name is Colleen and I've been employed with WorkSafe since 1999. I started off as an inspector and then moved into the investigation unit. And I'm also a health and safety representative. And I put my hand up for this role to keep abreast of any arising issues within the inspectorate and to be able to relay those back to my peers.
And Colleen, could you give us an example of one of those issues?
Before WorkSafe's head office moved to Geelong, there were a number of inspectors and investigators based at our smaller office in Yarra Street, and we were able to attend their meetings, they were able to attend ours. We could catch up with them on a daily basis in the tea room or just desk to desk, and we were well informed of what the inspectors were doing, what problems they were facing out in workplaces and so on, and we were able to relay matters that we found during an investigation to them. But once we moved to the head office, we were separated by floors, so we couldn't do that, and I felt that was a disadvantage to the investigators because we just had no idea what was going on out in the field.
Well, that's a great thing to do, Colleen. We know how important HSRs are in the workplace, and being the conduit for communication is so helpful. Moving on to you, Chris, could you tell us a little bit about some of the protections in place for HSRs?
Yeah, so the OHS Act does have a section within that has protections for HSRs. So if a HSR is speaking on behalf of their designated work group, for those people that might not think they've got a voice, they approach the employer and they have the conversations on behalf of the work group. There's a provision in the Act that says that an employer cannot discriminate against an employee that's raising health and safety matters or concerns. So they are protected. It's legislated that when they are being that voice, that the employer can't target them or treat them differently as a result of being that voice for people.
And that's so important, especially considering that an HSR is that voluntary role and they also have another day job. So that would impact that as well.
Yeah, absolutely. As you say, it is voluntary. They don't have to be that voice, but they're generally passionate people. The time needs to be given to them to be the HSR, but they are there to do that substantive role, the role that they're there for day in, day out, that they get paid for. But yeah, they need protections once they're being that voice for people.
And today we're talking about discrimination, and that's a term that's covered in lots of different jurisdictions and legislation. But today we're speaking specifically to discrimination under the Occupational Health and Safety Act and Section 76 of the OH&S Act, to be precise. Let's hear some specifics about that from WorkSafe's Manager of Industry and Representation Support, Anita Ford.
The Victorian OHS Act prohibits and imposes penalties on an employer if they dismiss, discriminate or treat an employee less favourably because that employee is or has been a HSR, exercises or has exercised powers as a HSR, assists or has assisted or even given information to an inspector, the authority, as in WorkSafe, an REO, or a HSR, and or raises or has raised an issue or concern about health and safety with either an employer, an inspector, the authority, an REO, or a HSR of an employee or of an employer.
So, Colleen, that also extends to prospective employees, doesn't it?
Yeah, if the dominant reason for refusing or failing to offer employment falls into one of the categories that we've mentioned.
So what could employee injury or detriment mean, for example?
Okay. In Section 76, the term injury is an employment law concept and doesn't relate to a physical injury. It relates to the changes to the employee's employment in a way that would be to their detriment. And you need to make an objective assessment of all the facts, but some examples could be dismissal, demotion, threatening either of those, allocations of tasks below one's skills, classifications, a reduction in allowances, fewer training opportunities, refusing a promotion or job advancements.
And these are things that WorkSafe take really seriously, aren't they?
Yeah, they certainly do. It is included in our compliance and enforcement policy and our general prosecutions guidelines as a priority. And if an employer or prospective employer is found guilty, they may be convicted, and the court may, in addition to imposing penalties, make an order that the offender pay damages to the employee and or make an order to reinstate or reemploy the person into their former position or similar.
Can you tell me about who has to prove the dominant reason was or wasn't one of those things?
Yeah, Section 77 in the Act is titled Accused Bears Onus of Proof. This is known as the reverse onus of proof, and this is the only section in the Act that activates the reverse onus of proof. This provision is activated in circumstances where all the facts constituting the 76 offence are proved except the reason for the accused conduct. If this occurs, then the onus of proving that the act of discrimination was not the dominant reason, as alleged, is a charge that lies on the accused.
And Chris, what about your experiences with discrimination against HSRs?
Yeah, so in my 7 years, I've investigated or been the inspector for a number of what we call Section 76 discrimination cases, where an employee has called up our advisory service and said that they've raised an OHS matter and they believe that their employer is now treating them differently as a result of that.
So Chris, as an inspector, what's your role as you work through that process?
Yeah, so in the first instance, we reach out to the complainant, the person alleging the discrimination, and we'll make inquiries as to what has transpired and ask for any evidentiary matters that they may have, such as documents or emails. Once we have all the supporting evidence, we'll then go and make inquiries with the employer. And once our inquiries are complete, we'll make a determination on whether the discrimination has actually taken place and whether that discrimination is the dominant reason for the treatment of the employee.
And I assume if they can't do that, that's when you would kick it up to Colleen's team.
Yeah. So there is a process that we go through, but Colleen's team follow on from the inspectorate in investigations.
And Colleen, coming back to you, as we've discussed, you're an investigator here. Have you ever worked on a discrimination case?
One that I remember pretty well involved a supervisor being terminated for raising a health and safety issue. The supervisor worked in a panel beating shop, and one Monday morning the employees arrived at work and noticed considerable dust all over cars, benches and tools within the workshop. And they had a suspicion it was asbestos because of the roofing materials. The supervisor and employees opted not to perform any duties until the dust was identified. Samples were collected and analysed and returned positive for asbestos. And that's all they were told about the asbestos and not informed of any risks in regards to health and safety. The employees were then told by their director to wear workshop dust masks and wipe the vehicles down with damp cloths and hose out the workshop. The supervisor refused, saying that they were not trained and did not have the right equipment. They were concerned about hosing the dust out into the public streets and into the gutters. And he was also concerned that there would be dust in the vents of the clients' cars that were being worked on in the workshop. The director then ordered air monitoring to be done to ease any fears, but the employees were not confident of the results as the monitoring was performed while they weren't working. So it wasn't a replica of the normal day-to-day tasks they had to do. The next day, the supervisor was terminated for not following reasonable work orders. and the other employees were threatened that they would be terminated if they didn't follow their work orders. So a WorkSafe inspector attended the site and advised that removal of asbestos-bearing dust is an asbestos process which must be carried out by a Class A asbestos removalist. It was investigated, and the outcome was the company was charged under 76 and fined $35,000.
So when you go into a workplace and looking for a potential case of discrimination, what sort of information as an investigator would you be looking for to kind of prove your case there?
This can be a long-winded answer, but in a nutshell, you want to look at talking to any witnesses, any supervisors, any HSRs or DWG members of the complainant, health and safety committee members, HR personnel, supervisors, managers, and so on. And then you would collect evidence in these matters.
And Colleen, if someone listening feels that they have been discriminated against under the OH&S Act, what should they be doing?
Yeah, contact WorkSafe. An inspector will be assigned to make inquiries into the allegation or explore their civil rights through the Industrial Division of the Magistrates Court Act. The inspector won't do that, but will advise that the complainant can do that.
Thanks, Colleen. Great to have you and Chris joining us. Just to recap some of the main points there, the OH&S Act prohibits employers from discriminating against HSRs, members of health and safety committees, and other employees, and penalties may apply. WorkSafe treats cases of alleged discrimination very seriously, and under its compliance and enforcement policy and general prosecution guidelines, will prioritise allegations of discrimination for comprehensive investigation. And if charges are laid under Section 76 of the OH&S Act, employers are responsible for proving the main reason for their actions and not the reasons outlined in the allegations. For further information on today's topic, you can check out the links in the text below. This has been another episode of the HSR podcast brought to you by WorkSafe, helping achieve better health and safety outcomes in your workplace. Next time, we're going to be joined by WorkSafe's Commander of Field Operations, Adam Watson, who'll share with some good examples of consultation on OH&S issues. Until then, if you have any OH&S issues or concerns, or to lodge a case, please contact WorkSafe's advisory service on 1800 136 089. You can also head to the WorkSafe website to subscribe to our monthly newsletter sharing news, events and resources for HSRs. And if you are an HSR in Victoria, WorkSafe has dedicated support officers available whenever you need help. Just email hsro@worksafe.vic.gov.au.
Please note, this information is based on laws applying in Victoria only. It is correct at the time of recording, but is not to be relied upon as legal advice. This episode does not outline all the legal obligations under Victoria's occupational health and safety laws.